Regala vs. Manila Hotel Corporation GR, number 204684, October 5, 2020, Hernando, J. Facts. Regala worked in Manila Hotel Corporation for 9 years as one of its waiters/cook helpers and was assigned to the food and beverage department. Regala was made to attend and participate in hotel trainings for basic food safety strategies, food safety awareness, and customer service awareness. Regala alleged that he was not recognized as a regular rank-and-file employee despite having rendered services to MHC for several years. Regala also claimed that MHC constructively dismissed him from employment when it allegedly reduced his regular workdays to 2 days from the normal 5-day work week starting December 2, 2009, which resulted in the diminution of his take-home salary. MHC denied outright that Regala is its regular employee and claimed that he is a mere freelance or extra waiter engaged by MHC on a short-term basis. MHC then presented a sample fixed-term service contract and copies of Regala's department outlet services contracts for extra waiters/cocktail attendants, service agreements covering the periods of his supposed temporary engagement with MHC. Issue 1. Whether or not Regala was a regular employee or a fixed-term employee of MHC. 2. Whether or not Regala was constructively dismissed from employment. Held. Regala was a regular employee. The employment status of a person is defined and prescribed by law and not by what the parties say it should be. In this regard, Article 295 of the Labor Code provides for 2 types of regular employees, namely, a. Those who are engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer, first category, and b. Those who have rendered at least 1 year of service, whether continuous or broken, with respect to the activity in which they are employed, second category. While MHC insists that Regala was engaged under a fixed-term employment agreement, the circumstances and evidence on record, and provision of law, however, dictate that Regala is its regular employee. First, Regala is performing activities which are usually necessary or desirable in the business or trade of MHC. This connection can be determined by considering the nature of the work performed by Regala and its relation to the nature of the particular business or trade of MHC in its entirety. Being part of the hotel and food industry, MHC, as a service-oriented business enterprise, depends largely on its manpower complement to carry out or perform services relating to food and beverage operations, event planning, and hospitality. As such, it is essential, if at all necessary, that it retains in its employee waiting staff, such as Regala, specifically tasked to attend to its guests at its various dining establishments. Second, the fact alone that Regala was allowed to work for MHC on several occasions for several years under various service agreements is indicative of the regularity and necessity of his functions to its business. Thus, the continuing need for his services for the past several years is also sufficient evidence of the indispensability of his duties as waiter to MHC's business. Regala attained regular employment status long before he executed the service agreements, considering that at the time he signed them in March 2010, he has already been in the employ of MHC for more than 9 years. Moreover, as discussed above, the nature of Regala's work is necessary and desirable, if not indispensable, in the business in which MHC is engaged. Undoubtedly, Regala has been a regular employee of the hotel since February 2000. At any rate, the service agreements and/or the fixed-term service contracts which MHC and Regala executed were only meant to preclude Regala from attaining regular employment status, and, thus, should be struck down or disregarded for being contrary to law, public policy, or morals. Yes. There is constructive dismissal where there is cessation of work because continued employment is rendered impossible, unreasonable, or unlikely, as an offer involving a demotion in rank or a diminution in pay and other benefits. Aptly called a dismissal in disguise or an act amounting to dismissal, but made to appear as if it were not, constructive dismissal may, likewise, exist if an act of clear discrimination, insensibility, or disdain by an employer becomes so unbearable on the part of the employee that it could foreclose any choice by him except to forego his continued employment. Being a regular employee of MHC, Regala is entitled to security of tenure. Hence, he cannot be dismissed from employment, constructive or otherwise, except for just or authorized causes. Patently, the reduction of Regala's regular workdays from 5 days to 2 days resulted to a diminution in pay. Regala's change in his work schedule resulting to the diminution of his take-home salary is, therefore, tantamount to constructive dismissal.